Jesse, thanks for calling in. What can I do to help you today?
Well, we've developed several prototypes of the NGT. Our focus group research looks promising, and I think we're at the point where it makes sense to begin manufacturing and distribution. In doing the prototypes, NGT has been working closely with this manufacturing company, and I've spent a lot of time with the principals, and I really like them. They're my first choice for this, and up to now things have been on a handshake deal, but I'm not sure that's such a good idea if we ramp up. Anyhow, I need to learn how contracts work so that I can come in. So I came in to ask about what are my options.
Well, contract law is a huge area, so it's going to take some time to give you an overview. But you have to understand that we not only have to consider a contract for this manufacturer, but also for other aspects of how you're going to do business. In fact, you've already signed a contract when you signed the lease for the building. So let me give you the overview of what the contract law is involved, and then we can chat a little bit more about what your options are and then go from there. There are two sources of contract law. First is common law, and that's true for all contracts except sales and leases. And then if you do have a sale or a lease contract, it's governed by something called the Uniform Commercial Code, or the UCC. And there is federal UCC law, and states have UCC law. Most really mimic each other. So a contract is a promise or a set of promises, which if you breach, there's a remedy, and the performance of which the law in some way recognizes as a duty. So under something called the objective theory of contracts, the circumstances are required to determine the intent of the parties. Was there intent to make a contract? Was there intent to have an agreement? Now the elements of a contract are as follows. You have to have an agreement called offer and acceptance. You have an offer, you have acceptance, and then you have to have consideration. Something of value must be part of the bargain. You have to have contractual capacity. In other words, you can't contract with a minor. There has to be legality. The contract has to be over something that's legal. You can't have an enforceable contract to sell cocaine, for example. And the defenses to that there was a contract are, first, the genuineness of assent, and then the form of the contract. Did it meet all the elements above? So the types of contracts that are out there is something called a bilateral contract versus a unilateral contract. Bilateral is the offeree, or the person who is on the other side of the offer must only promise to perform, promise for promise. Unilateral is the offeree can accept the offer only by completing the contract performance, which is called promise or enact, and it can be irrevocable. In other words, once performance begun, it cannot be revoked. There's also express versus implied in fact. Express are basically words that are oral or written. Implied in fact is that conduct creates and defines the terms of the contract. It would be that someone furnished a good or service, someone expected to be paid for that good service, the other side had the chance to reject it, but did not. That forms a contract, even though there might not have been any oral agreement per se of I'm going to do this for you. If you have contract performance, it can be either executed or executory. Executed is that a contract's been fully performed on both sides. It was executed and done. Executory is a contract's not been fully performed on either side. In order for a contract to be enforceable, first it has to be valid. It has to meet all the elements we went over before. And the elements are agreement, consideration, contractual capacity, and legality, once again. It can be void, in which case there is no contract at all. If, for example, the contract was on something that was illegal, then that's basically void. Or voidable, in other words, a valid contract that can be rescinded in some way and thus is enforceable. There are also things known as quasi-contracts. And quasi-contracts are implied in law. And in essence, they're fictional contracts created by the courts. They impose on parties, basically for the interest of fairness and justice. It's something in law called quantum meruit, which says that if you don't have a set price, then the court can find what would be a fair and reasonable price. These are things such as also as equitable remedies. Equitable remedies are where the court basically can issue an injunction to prevent some substantial harm from happening. And there are limitations on how much you recover under quasi-contracts. Now, if you're interpreting contracts, basically the courts tend to use the plain meaning rule. In other words, they give the terms their most obvious or ordinary meaning. But there are other rules of interpretation. If terms are ambiguous, the court will attempt to interpret the ambiguous contract in a reasonable, lawful, and effective manner. So you read your credit card contract and you don't understand it, the court will give it a plain meaning to it and go from there. In doing this, the court will look at the whole contract, not only just particular sections, but they're interpreted as a whole. Their terms are negotiated separately at given weight, so if there was separate negotiation on a specific paragraph, the court will give that greater weight. Otherwise, ordinary common meaning is what's given. Specific wording is given greater weight than general language. Written or typewritten is given greater weight than pre-printed. Pre-printed is known as an adhesion contract. We'll talk about that in a bit. Ambiguous terms are interpreted against the drafter. So if it could go either way, it'll go against the side that actually drafted the agreement. And then trade usage, prior dealing, how a similar contract was carried out previously between the parties, the court's performance, those are allowed by the court and viewed by the court as a way to clarify what happens. Now, let's talk about offer and acceptance. Okay, so the offer and acceptance is the agreement. And the parties have to show mutual assent to the terms of the contract. Once an agreement is reached, if the other elements of the contract are present, the consideration, legality, and so forth, a valid contract is formed. So, in order to have the offer, it has to, first of all, be a serious intention. Courts will basically say, no, it was obviously not serious, someone was making a jest. They're not going to enforce that. There has to be definitives of terms. In other words, it's got to be very clear what was to be done. I will do this. There has to be a communication to the offeree. In other words, it has to either be an oral or written communication, except for those contracts that are implied in fact because of previous dealing. You drive up to the gas station in states where they still have got a gas station attendant. The gas station attendant comes over, you never speak to them. They fill up your gas tank, basically go to you and wait for the money. You can't get to drive away saying, oh, I never asked for the gas to be pumped. So, in terms of serious intention, it's judged by what a reasonable person in the offeree's position would conclude about the offer. The offers made in anger, just, undue excitement are usually not considered to be offers. Expression of opinion, not offers. So statements of intention, preliminary negotiations, agreements to agree are not considered offers. Advertisements, catalogs, price lists, circulars, those are treated as invitations to negotiate and not as offers. And then auctions are not considered to be offers until basically the final hammer falls. Now let's talk about, again, definitives of terms. The terms can be either expressed or implied, and in terms of that, you're looking at the identification of the parties, the object or subject matter of the contract, the consideration to be paid, and again, that's the money, and the time of the payment, the delivery, or performance. Those are some of the terms that they're looking for specificity in order to determine whether or not this is a generally enforceable contract. And then, how is it communicated? Well, first is the offeree's knowledge of the offer, either directly by the offerer or by use of agents. The offer can be terminated, and it can be terminated prior to acceptance by either party, either by actions of the party or by operation of law. And if you do it by action of the parties, what we're talking about is that there's a revocation of the offer by the offerer, and can be drawn any time before there's an acceptance of it. It's effective when the offeree's agent receives it, the exception, of course, being irrevocable offers. And these are things like an option contract. If you are in the stock market and play options, the promise to hold an offer over a specified period of time in return for consideration, that's irrevocable. Or if there's a detrimental reliance, what we call promissory estoppel. In other words, the offeree relies on to his or her detriment. That bars it from being revoked. Or there's detrimental reliance and partial performance, where the offeree partially performs. That prevents it. All right, so how can it be terminated by the actions of the buyers? Well, first, a rejection. No, I don't want that. And it could be either expressed or implied, and it's effective only when received by the offerer or the offerer's agents. Or there is a counter offer. Okay, I offer to sell you this widget for X amount of dollars. No, but would you consider Y amount of offers? That is a counter offer, therefore there's no original contract. Or it can be terminated by operation of law. That could be a lapse of time. It could be when a specified period of time in the offer is specifically passed, or a reasonable period of time. Or what you're bargaining about can be destroyed. Or there's death or incompetence of either party. Or there's a supervening illegality, the offer to buy cocaine, for example. All right, so let's talk about the other side of the agreement. We've talked now about offer, let's talk about acceptance. And acceptance can be voluntary act by the offeree that shows assent to the terms of the offers. Those are the elements that you're trying to hit. And it's unequivocal. It's called the mirror image rule. I will sell you this widget for $3, and the other side hands me $3. Boom, we've got a binding contract. Silence can be acceptance. For example, acceptance of services. You pull up to the gas station. You never say a word to the gas station attendant. They you decide to pump your gas. You don't say stop. That's basically acceptance of the service. Sometimes there is a duty to speak, but not always. Or prior dealings. We've been making this delivery to this person for that price for quite some time, and it just basically is custom and habit. Or if there are solicited offers, then the offeree has got a duty to reject. Let's talk now about the timeliness of acceptance. There's something called a mailbox rule. In other words, the acceptance becomes effective on dispatch of the basically of the offer by an agreed form of delivery. So I receive a offer, buy my widget for $3, and I put a check in the mail for $3. That basically delivery mailbox rule is acceptance of the contract. And this was where the offerer expressly says how acceptance should be made, and it's effective when it's dispatched, mailed or shipped. Exceptions are, if it's not properly dispatched, I don't put the check in the mail. If the offerer specifies that it will be not effective until received, not when you mail it, but when I actually get the $3. If the acceptance is sent after rejection or a withdrawal. So, with technology, we no longer talk about delivering things or mailing things anymore. We do it all electronically. So these rules have changed a little bit. But we're not talking about traditional rules of acceptance via FedEx, email, or fax. It's generally that type of stuff, and that's why the mailbox rule generally does not apply to online offers. When you click the button, now that's an acceptance. All right, let's talk about consideration. This is the valuable thing that is negotiated and paid, how you pay. And usually it's money, but it's going to have legally sufficient value and a bargain for exchange. So it could be a trade of services. It doesn't necessarily have to be money. It could be something of value. So legal value can mean a promise, performance, or even a promise not to do something, what's known as forbearance. So some agreements lack consideration. You have a pre-existing duty in order to do it, and that's a promise to do what you already have a legal duty to do. That's not legally considered as sufficient consideration, unless there are unforeseen difficulties or there's a rescission and new contract. In other words, the previous contract is rescinded and revoked, and you bargain for a new contract. Some of the issues you have in consideration is past consideration is not consideration, because you have to have that bargain for element. So basically the bargain for element has got to be contemporaneous with the agreement on what the consideration is going to be. And there can be illusory promises. The promiser is not definitely promised to do anything, sort of a think about it type thing. That isn't consideration. And also if you have an option to cancel clause. So there's also something called promissory estoppel. And promissory estoppel is going to be clear and definite promise. And it's a promise that must justifiably rely on the promise, and the reliance is substantial, and justice will be served by enforcing the promise. In other words, promissory estoppel is I did something in reliance on the offer that you made. So promises to pay debts that are barred by the statute of limitation is an example of that. Or charitable subscriptions, tithing is an example of it. You also have got to have capacity. And what capacity basically means is legal ability to enter into the contractual relationship, meaning that the person, people bargaining, have got to have full competence. If they don't have competence, they have limited competence, then you don't have a full bargain. And then the legality. It basically has to be something that's not criminal, torture, or anything that's opposed to public policy. The best example, kind of bargain to sell cocaine. So if you have minors, guess what? A person is no longer a minor for contractual purposes at the age 18. A minor can enter in any contract that an adult can. A contract entered by a minor is voidable at the option of that minor. So in other words, the minor can get out of the contract, but the minor can also say, no, I agree to that, and at that point it's a valid contract. So a contract with a minor is voidable. I can tell you a little war story about this. I knew an attorney who had a client who was an up-and-coming web entrepreneur, was building their business but got into hot water and owed about $3 million. All the people that money was owed to were suing this entrepreneur. So the lawyer called a meeting at his office, and all the people that owed money showed up. And at the head of the table was sitting this young man. And they all turn and say, "Who's this young guy?" And he says, "This is the person who you made your contract and bargained with. He's 16 years of age. And he wants to make good on you, but it's a voidable contract. He doesn't have to pay you a thing because you cannot contract with a minor. That contract is voidable. But we'll offer you 10 cents on the dollar." They all took the 10 cents on the dollar. So a minor's got the right to disaffirm. It can be deferred any time during the minority or for a reasonable period of time after the minor comes of age. So minor makes a contract. Once they turn 18, it can be enforceable. If they turn 18 and basically disaffirm a week later, that's okay too. It must be for the entire contract, not just be for parts of it. And the disaffirms can be either expressed or implied. Minor's got obligations on disaffirmance. The majority rule is the minor need only return the goods or other considerations subject to the contract, provided the goods are in the minor's possession or control. So in the example I just gave you of that war story, the minor had actually used all the things that basically have been accepted. There's an increasing number of states that hold the minor must restore the adult position held before the contract was made. But that is still the minority rule. Some exceptions are misrepresentation of age. Generally, the minor can disaffirm the contract if the minor lied about how old they were, but some states prohibit this and hold the minor liable. And contracts for necessities. Contracts for food, clothing, shelter can be disaffirmed by a minor, but the minor remains liable for the reasonable value of those goods and services. So that's an exception to the right to disaffirm. Also, insurance. Not used in accessories, so minor can disaffirm the contract and can recover all the premiums. Loans. These are seldom considered to be necessaries. The exception of loan to a minor for the express purpose that the minor can purchase necessaries. That's enforceable. All right. Or there's ratification. When the minor reaches age, they say, yeah, look, I'm going to ratify that contract. They're bound, even though it's basically made while they're a minor. And that's true for both executive and executory contracts. So with a minor, is a parent liable for their contracts? And the answer is no. And this is why parents are usually required to sign for the minor. Because once they sign, now they are liable, but they're not liable if only the minor was the one that signed. And for torts, it varies from state to state. Some states, the minor is personally liable for their own torts, but liability can be imposed on the parent for willful acts of their minor children, and liability can also be imposed on parents for negligent acts that results in the parent's negligence. So if the parents do not properly supervise the minor, and the minor holds the big party at the house, someone gets hurt, parents can be held liable, especially because there's a lot of social host liability laws now. Intoxication. If you're drunk, basically at the time the contract is made, then you don't have capacity. It can be either voidable or void. The courts are going to look objectively in terms of deciding which is which. If disaffirmed, it's voidable. The person's got the option to disaffirm. In other words, they sober up, say, oh, I didn't mean to do that, or they can ratify it at that time. If there is mental incompetence, it can be void. If the person has been judged mentally incompetent by a court of law and a guy's been appointed, the guy can say, we're not going to do that contract. Or if it's voidable, the person doesn't know they're entering into a contract or didn't have the requisite mental capacity to do so, to comprehend what was going on, that's just simply voidable. But if the person is able to understand the nature of the contract, yet lacks capacity to engage in other activities, the person is lucid, has a lucid interval, so to speak, that can be a valid contract. Okay, legality is basically contract for something that is illegal. So if it calls for a tortious act, or it calls for an act contrary to public policy, or for a criminal act, those basically all lack the legality. And then there are contracts that are just simply contrary to statute. So a contract to commit a crime, that's not enforceable. Usury, charging over a high rate of interest, which varies somewhat from state to state. Gambling online is sort of an iffy one. Some states are now making it a valid contract, but other states don't. The Sabbath laws, some states basically say contracts made on a Sunday are not void, and that's why sometimes stores aren't open on Sundays in some states. Licensing statutes, where you can make a contract, but the state says no, you have to have a license for it. If you don't have the license, it's not a valid contract. Other things, contracts that are contrary to public policy, can be considered void. Unconscionable contracts, things that the court looks at and just say, this is just simply unfair, the court can void that. And they can be procedural or substantive unconscionability in terms of how the court decides if something is just simply too far overreaching. That's what unconscionability means, overreaching. Or there's some exculpatory clauses in there that it really gives a whole out to one side but not the other. Or if a contract is discriminatory, that is not enforceable. Or if you're going to basically commit a tort deliberately, that is not enforceable. Or if it's anti-competitive, a restraint of trade. There's an exception if you have a sale of a business, covenant not to compete, that is enforceable. Covenant not to compete, basically employment contracts in some states is enforceable, even though that's tending to go away at this point. And then finally, contracts that promise to discriminate, those also are not enforceable. So here's a little chart, basically, in terms of what it would be in terms of procedural unconscionability and substantive unconscionability, and the factors that the court will consider in deciding whether or not this is an issue. So if it's illegal, generally means it's void, so no contract happened whatsoever. Justified in ignorance of the facts, someone's a member of a protected class, withdrawal from a legal agreement, contracts made because of fraud, duress, or undue influence, or severable or divisible contract, those might be exceptions, especially if, in terms of severability, that portions of the contract are enforceable but only a section is, the courts will basically throw out the section that's unenforceable, but let the remainder remain in place. So how are contracts enforced? Well, they could be unenforceable if the parties haven't generally assent to its terms by either mistake, in other words, both sides made a mutual mistake as to what the contract was about, misrepresentation, one side misrepresented themselves, didn't tell the full facts, undue influence, basically someone was forced into it, or duress, very similarly, they were under duress to do it. There are things known as mistakes of fact, and this allows a contract to be canceled, and it can be bilateral. In other words, if both were mistaken about the facts surrounding the contract, it can be rescinded by either party. Unilateral mistakes cannot be canceled unless the other party knew or should have known that there was a mistake of fact going on, and if the mistake was due to a mathematical mistake, basically, and was inadvertently and without gross negligence, that is something that can be canceled. Mistakes of value is another one. Generally, a contract is enforceable by other parties of a mistake of value unless it was of a material fact. Then we turn to fraudulent misrepresentation, and it's avoidable by the innocent party, not by the guilty party here. And the elements of that are material fact is misrepresented, there was an intent to deceive, there was a reliance on the misrepresentation, and there was an injury to the innocent party. And that's where we talk now about opinion versus fact. Or with misrepresentation has occurred. This misrepresentation can be either expressed or implied, and this misrepresentation of future facts and statements of opinion, that's not fraud unless the person professes to be an expert. That's why you hear all the stockbroker ads saying, past behavior is not necessarily a guarantee of future behavior. Misrepresentation of the law is not fraud unless the person's got greater knowledge of the law. So a lawyer basically has to worry about this. And silence is not a fraud unless there's a serious problem or a defect known or asked and the person lied about it. Next, you have the intent to deceive. And scienter is the fancy name for intent to deceive. And this is where a party has knowledge of a fact is not as stated, but stays silent about it, or the party makes a reckless statement without regard for the truth, or the party implies the statement is based on personal knowledge or investigation. Those are all indicia of intent to deceive. And it has to basically be gross negligence in terms of determining if that is part of the intent. If there's reliance on misrepresentation, then the deceived party must have justifiable reliance on it, and that really depends upon their knowledge and experience. If there's injury to the innocent party, there's no proof of injury required when the action is to rescind the contract. If it's to recover damages, then the proof of injury is required. You have to prove that you were damaged by the representation. And there's also non-fraudulent misrepresentation. And this is innocent misrepresentation. They really thought what they were saying was true. And there's also negligent misrepresentation. Now this is equal to scienter. It's treated as fraudulent misrepresentation, even though it wasn't purposeful, but it was basically in the context of negligence. All right, let's talk now about undue influence. And if you have undue influence, then the contract is voidable. In other words, they can be backed out of, but they can ratify and say, no, I'm going to go ahead with it. You see if there's a confidential or fiduciary relationship, there's a relationship of dependence, there's influence or persuasion, there's a weak party talking to something not beneficial to him or herself. Those are all indicia of undue influence. And there's a presumption of undue influence if you have any of these above categories that people fall into. Duress is like undue influence, but a little bit different in that you force the party into the contract under fear or threat, and that makes it voidable as well. And the threatened act must be wrongful or illegal. I will harm you if you don't do that. So threat to exercise legal right, sue, basically, I will have you arrested if you don't do this, or economic or physical. All right, now, there are things called adhesion contracts, and these are standard form, pre-printed contracts in which the party has got no opportunity to negotiate the terms of the contract. It's a take it or leave it type deal. they can be considered unconscionable. Courts have found that and have thrown them out. It's a one-sided bargain where one side has got superior bargaining power. Because contracts are all about bargaining for that offer and acceptance. That's really what the courts are assuming. And last, we have something called the statute of frauds. And the statute of frauds is important because it's very old, passed in 1677, and it says that certain types of contracts have to be in writing, particularly contracts for real estate. Purchase, sale, lease agreements, those have got to be in writing. And now that statute is pretty much in every state. So these are interest in land, things that basically can be performed within 1 year, collateral or secondary contracts, marriage contracts, contracts to sell goods priced $500 or more. Those all require some type of written contract. Land, purchase sales agreement, everything that has to do with the land, all the fixtures, all that type of stuff, things that we talked about in the last class, those are all basically part of a written contract. So mortgages also are part of it. And the 1 year rule says that if a contract cannot be performed within 1 year from the day it was formed, it has to be in writing. So again, a contract that it takes more than a year, you have to have in writing. It runs the day after the contract is made, and where it's possible, even though unlikely within 1 year, it's basically the possibility of it being done. Collateral promises, this is where we talk about the primary versus secondary obligations or the main purpose rule exception. And here's a good example of it. So you got basically party A has an original contract with party B, owes money, and C basically is required to have a signed writing to basically institute for A's debt because A and C make a deal. That has got to be in writing. So B can't look to C. Let's say that C owes A the same money. B can't look to C unless there's a written agreement by C saying, okay, I will pay on behalf of A. Marriage, prenuptial agreements have got to be in writing to be enforceable. And there's got to be some consideration for it. So this is why you see typically in prenuptial agreements, this is what you're going to receive out of my assets prior to the marriage. And they're not enforceable if it's not voluntary. And this is where you get into the whole issue of duress or undue influence. And the Uniform Commercial Code, you remember again, everything having to do with sale, leases is governed by the Uniform Commercial Code. For contract, if it's worth $500 or more, basically you've got to have a writing or a contract for it. The exceptions are basically if there's partial performance, if there's promissory estoppel, and there are some special exceptions under the Uniform Commercial Code. So if you have a statute of frauds issue in terms of is the writing enough, it has the name, the subject matter, the consideration, all the offer acceptance and that type of thing, and signed by both sides, well then that's enough of a writing. If it's under the UCC, okay, and that would be for sale of lease of goods, you only need the name, the quantity term, and the signature of the party who's going to be charged. There is something called the parole evidence rule, and this is that oral representation of promises made prior to the contract cannot be admitted into court because the court will say, well, maybe you did talk about that, but that's not what you put down in writing. So that's why you can have all the representations in the world and all the promises made, but it's what is in writing is what is going to be the terms of what the court is going to enforce. There are some exceptions. That would be is that if the contract after the writing was subsequently modified, it's a void or voidable contract, and all the things that we looked at before, or it contained ambiguous terms. The court will look to basically what oral representations were to try to get a definitiveness of what those terms mean. Or if you had prior dealing, or there's a specific usage of trade term that people just understand in the trade that this is what this means, those are all basically exceptions to the parole evidence rule.
Again, that is a lot of stuff. And listening to it, I think NGT needs more than just one contract. Besides this manufacturing issue, NGT is engaged in all sorts of stuff involving contracts, like where we're located, the people that work for us, and come to think of it, I think one of our programmers is only 17. I mean, we should have written agreements with all of them. So, what do you recommend?
Oh, great questions. And again, here's what I think we should do. I'm going to ask the firm's associates to research this large area of law for you, put together an overview about contract law, and then put that into a written memorandum with their recommendations about what they think you should do. That way you can see what all your options are, and you can make an intelligent decision about how to go forward. How's that sound?
Sounds great. Thanks for speaking with me today, and I look forward to getting that memorandum.